Hi there, folks. It's James from Quails here. Can I just check that the audio is working okay? Those of you that have been involved in one of these webinars before, can you raise your hand or press the button that looks like a hand? Terrific. Thank you, guys. Welcome to part 2 of a webinar series that started yesterday looking at abuse on contact. Yesterday's session, for those that weren't a part of it, looked at domestic violence and abuse on contact, and we had speakers from Women's Legal Service, Talira Centre, which provides counselling service to children and young people affected by domestic violence, and someone from the Domestic Violence Action Centre in Ipswich. In today's second session, we'll be looking at some of these issues through a bit more of a legal lens, and that discussion will be led by Steph Ewart, who's the Acting Principal Solicitor at Women's Legal Service. Can I begin today's session by acknowledging the traditional owners of the lands on which we are dispersed across the country. I'll particularly pay my respects to the Yagara and Turrbal people here in Brisbane, but acknowledge traditional owners across Australia where we do have people tuning in today. For those that haven't used this webinar software before, can I ask you, if you don't mind, to hold your questions until the end of the webinar, unless it's a really burning issue, in which case there are two ways that you can ask questions. One is to press a button that looks like a hand. We'll see a hand pop up and we can unmute your microphone. The other way that you can ask a question is to type a question into the questions box. But as I say, with this kind of technology, or the limitations of this kind of technology, it might be best to hold those questions until the end. I think that's kind of all we need to know from a housekeeping and technical kind of perspective. So I might hand over to Steph Ewart from Women's Legal Service to talk about allegations of abuse and parenting arrangements. Thanks, Steph.
Thanks, James. Good morning, everyone. I'm going to run through a couple of things today. Firstly, looking at the Queensland Domestic Violence and Family Protection Act provisions. Apologies for those in other states, this won't be directly relevant to you, but it is a small part only of the what we're covering today. Then I'm going to talk about the Family Law Act and briefly about the nexus between the Domestic Violence Act and Family Law Act provisions. Talk a little bit about setting up appropriate parenting arrangements where you're asked to advise clients in this situation, and where allegations arise and there already is some parenting arrangements in place. We're going to talk about what the procedure is, where there's no orders in place, when there are orders in effect, or when there's already current proceedings on foot. So looking at the Domestic and Family Violence Protection Act for Queensland, and this would generally apply a lot of it to other states as well. How to advise clients generally in this situation: safety first, so provide or refer people for safety planning and provide them with the relevant emergency contacts, which would at the very least be police, 000 in your local station, and in Queensland DV Connect. Generally, the grounds for orders under that Act are set out in Section 37. There's got to be a relevant relationship between the parties, which is some sort of intermarital family relationship or an informal care arrangement. There's got to have been domestic violence, and that is widely defined in the Act. If, for those who were listening in yesterday, you would have heard Beck go through the various kinds of domestic violence, and all of those are covered and recognised as forms of domestic violence for this purpose. And then for obtaining final protection orders, it's also required that you show that it's necessary or desirable for the order to be made. I should say that in preparing this presentation, I tried to pack a lot of the information, so the section references, etc., into the actual PowerPoint, so you'd have that as a ready reckoner, and it'll be sent out after the presentation. But I haven't gone into a lot of detail in the presentation or in the PowerPoint about relevant case law. If anyone has any interest in particular points and having those elucidated further with case law, I do have some handouts along those lines which I can have sent out as well. So please just hold those questions, refer to them at the end, and I'll make a note of those things and make sure they're covered in the additional material. Clients who have children and are seeking protection orders, there's a couple of things to be aware of. The basis for including children under the order is set out in the Act. A court must consider naming a child where there is a child of the aggrieved or living with the aggrieved, and Section 53 sets out the situation where the court may name a child where it's necessary or desirable to protect the child from associated domestic violence or being exposed to domestic violence committed by the respondent. There's a great deal of inconsistency and variability across the state in terms of magistrates who are very willing to include children on protection orders and those who are very reluctant to do so. Successful applications will be the very unambiguous circumstances. So if there has been direct, physical or other obvious forms of violence towards a child and that is set out in the application, it will be a successful application in naming the child on the order almost certainly. Unsuccessful applications tend to be those where it appears from the application and to the magistrate that the aggrieved party is effectively trying to arrange parenting matters by virtue of the protection order. So you will see protection order applications where parties have set out in great detail not much about the violence that they allege from the respondent, but a great deal about their difficulties with making parenting arrangements. They might talk a great deal about children not wanting to go on certain types of arrangements. They might talk about difficulties at changeover, but the tenor of the application will be largely about parenting arrangements. This tends to set up a red flag to magistrates who will be almost to a man very reluctant to make orders if they get the idea that they are simply being used to effect parenting arrangements. They will want people to be going to the family law courts and seeking those arrangements through parenting orders in those courts, which we'll talk about shortly, and those applications tend to fail. Obviously, there is a huge body of applications which are neither the obvious successful nor the obviously unsuccessful applications, and they fall somewhere in the middle. So they haven't got a great set of unambiguous circumstances, but the children have been exposed to a lot of domestic violence, and there are parenting arrangements in question, but it's not the entire tenor of the application. Those are the difficult applications. If you're advising clients on preparing an application, the obvious advice to give them is to limit the information in their application to the domestic violence that they have been exposed to and their children have been exposed to. If you already have an application that you're attempting to appear or assist the client to appear on, and it does mix up both of the issues in the one application, then your job is to winnow out the parts of it that are purely about parenting arrangements and assist the client and therefore the court to focus on the actual domestic violence, which will have to be the basis of the orders made. In terms of the conditions that can assist people to protect children under protection orders, there's a few. The standard conditions, which must be part of every order, are that the respondent be of good behaviour and not commit domestic violence or associated domestic violence against a named person, which can include a child. Other conditions can be that the respondent not approach within a certain number of metres of the aggrieved and certain addresses, including schools, daycare centres, so they can be specifically tailored for the protection of children. There can be no contact orders, meaning no contact by phone, text message, etc. And ouster orders can be made under Sections 63 and 64 of the Domestic Violence Act to require a respondent to leave a family home so that the aggrieved and children can remain there. I put a point on the PowerPoint about considering whether protection of an aggrieved is sufficient to protect children without naming children. That's not to suggest that that's the best course or it should be your goal, but it's something to be prepared to answer. If the respondent is represented, then you can expect to have this question raised by them. You can also expect to have it named by some magistrates. So the magistrates who are reluctant to name children on the order and who are concerned that the order will become a de facto parenting arrangement will often seek to question a representative or a party about whether the children really really need to be named, or whether it's not sufficient that the aggrieved person is named. There would be some situations where it may be perfectly sufficient. For example, if you have a very young infant that is with an aggrieved mum the entire time, not leaving her care, with her at all times, and you have conditions to protect her in terms of not approaching within certain numbers of metres, no contact, oust orders, etc., that might be perfectly sufficient to protect that small child. Where it gets more complicated is where children are off in the world attending daycare and schools, and there's nothing in particular to protect those children unless they are named on the order. So certainly turn your mind to whether it is sufficient to simply name the aggrieved adult, or whether it's required to name the children, and marshal your arguments about why the children need to be named as well. So specifically look at what domestic violence has been either directed towards them or they have been exposed to, so that you're ready with those answers to those questions if and when they almost inevitably arise. Whether there are current parenting orders, the Act does require the magistrate to make conditions limiting contact between a parent and a child only to the extent necessary for the child's protection, safety and well-being. And you will see some magistrates be very proactive about ensuring this, so looking to tailor conditions to ensure that it's not going to, that they're not going to unduly limit that contact. So again, be very clear about the conditions that are required, why they're required. If you're drafting an application, ensure that the instructions about these things are in the application, so that those arguments can be made before the magistrate effectively. Otherwise, you do tend to see things being watered down. Orders will typically have an exception clause, which I've set out there, which will allow an order to be made providing for all sorts of conditions, but saying that they will not limit the parties attending either conference, counselling or mediation, or having contact with a child if it's set out in writing between the parties or pursuant to an order of the court, or contact that's organised by Department of Communities Child Safety. So that's a fairly standard exception, and it's useful to carry with you to court if you're thinking that you might be drafting these kind of arrangements by consent or on the spot, or making submissions about them. But magistrates will typically put that in as a fairly general rule. This is their way of ensuring that they are taking account of any family law court orders that may be made in the future, or that may be made now. It is incumbent on the applicant to disclose a family law order under Section 77 of the Domestic Violence Act. However, this is not always done. Magistrates will typically say, well, if we don't know about it, we can't do anything about it, and will make the point very strenuously that it's very important that people disclose these orders and, if possible, provide copies of them. But of course, it's not always possible where things are being done urgently or in an emergency situation. So things do have to be caught up afterwards. If the magistrate is aware of the family law court order, that's when they can make the exception type of condition to allow for the order to continue, if that's the intention. However, the magistrate's court can still consider a family law order and revive, vary, discharge or suspend it under Section 68R of the Family Law Act. And this is where we start to get into this nexus between the Domestic Violence and Family Violence Protection Act and the Family Law Act. So certainly state magistrates' courts are empowered under the Family Law Act to suspend or discharge orders. Suspension would be the more typical arrangement or a variation, and that's not a common order to be made, but it's certainly something to keep in mind if you're advising parties in relation to this or appearing for them. The family law court orders do invalidate family violence orders to the extent of any inconsistency under Section 68Q of the Family Law Act, but there's been an ongoing debate in Queensland about whether a later domestic violence order will automatically invalidate a family violence order, or whether a court has to specifically suspend or vary that family law order under Section 68R. There's views on both sides of this debate. My own view, for what it's worth, is that a domestic violence order will not automatically invalidate a earlier family law court's parenting order, and that it's incumbent on the magistrate to specifically vary, discharge or suspend that family law court order under Section 68R and say that they are doing so. If you're assisting clients to prepare for a magistrate's court matter involving a protection order, or you're appearing for them, I recommend preparing to ensure that the magistrate is clear about what is actually happening. So either the magistrate, hopefully the magistrate is told that there is an existing family law parenting order, and either the magistrate is going to expect that order to continue and thus is going to make that exception to allow for that to happen, or the magistrate is going to specifically vary or discharge or suspend that order under Section 68. So as long as you are clear about what you're asking the court to do, or you're assisting your client to be clear about that, and you're clear about what the court has done, that should avoid any confusion, and it won't matter what the debate is about which order should be invalidating the other, as long as the domestic violence order is clear about what has actually been done. Something to be aware of is that where Section 68 orders have been made, so a magistrate's court has, say, varied or suspended a family law court's order, that arrangement expires when the interim order stops being enforced, or after 21 days, whichever is the earlier, under Section 68T of the Family Law Act. So typically this will be an emergency stopgap measure where people are in court at fairly short notice, and they just need some breathing space to get on top of an application in the family law courts, or for a party to be served and back in the magistrate's court, and that's why there's quite a short period of time to do that. But just be aware that that time obviously will tick through quite fast, and people need to be prepared immediately with their next step, whatever that's going to be, whether it's back to the magistrate's court or whether it's into the family law courts to deal with the matter. So we're moving on to the Family Law Act now, and how to advise clients generally about parenting. When parties are separated, there's a few things that they need to sort out. They need to work out who's going to have parental responsibility for children, which is making the big decisions for them: education, health, religion, change of name, things like that. They need to work out what parenting arrangements they need to make, so which parent they're going to be living with, or whether they're going to be living with both under a shared care arrangement, and if that's not happening, what time they're spending or communicating with the other parent. They can also address any specific issues that they want to include about their arrangements for children, and typically those would include things like communication, travel, arrangements about schooling, etc. The overarching principle is that the children's best interests are paramount. That's set out in Section 60CA of the Family Law Act, and Section 60CC sets out a whole heap of factors that the court considers when they're working out what the child's best interests are. But effectively it's everything that can relate to a child in any given circumstances, about working out what's in their best interests. If you're advising a client and there are allegations of abuse and they're trying to set up some parenting arrangements, there's a couple of things to be aware of. The first thing's in relation to parental responsibility. The options for parental responsibility are either that it's equally shared by the parties, or that one party solely holds that parental responsibility. And a simple parental responsibility order will simply say that. It will say that the parties equally share parental responsibility for the children, names, dates of birth, etc. Or that the mother is has sole parental responsibility for the children, names, dates of birth, etc. That's a simple parental responsibility order, and that is effective in lots of situations. But where you get allegations of abuse, you need to turn your mind to whether that's the best approach, or whether it's best for there to be a prescriptive order. You also need to turn your mind more than you might in other situations about whether parental responsibility should be equally shared or sole. So there certainly are examples in the case law about parental responsibility falling to one party alone where there are serious allegations of abuse, but typically parental responsibility will be equally shared. Where it is equally shared, the simple order will not require anything specific of a party, whereas a prescriptive order will set out a number of steps that the parties have to go through. For example, it will have a number of subsections under the general section saying that the parental responsibility is equally shared, and those subsections will cover issues such as the party who identifies that there is a decision to be made will notify the other party of the decision to be made within 7 days. Subsection B, the party who has received the notice will respond within 7 days. Subsection C, the parties will make a genuine effort to come to an agreement about the decision to be made, and perhaps you might have or refer to some mediation or other FDR arrangements in here. And then the orders can go so far as to say, where an agreement is not reached, which party is to have the final say. Parental responsibility orders can also be divided up so that one party will be given sole parental responsibility for some issues which have tended to cause difficulties for the parties in the past. For example, if you have a child with serious health issues and the parties have traditionally failed to be able to come to agreement about that, and the court has or is likely to decide that one party is the better decision maker in that situation, so either more available or more likely to make a decision in the child's best interests, then that particular issue could have sole parental responsibility falling to one party, whereas parental responsibility could otherwise be equal. There's pros and cons where there's allegations of abuse about whether the simple or prescriptive orders are the best. Simple orders obviously don't require anything specifically of a party, but it does leave parties to their own devices in making the situation up as to how they're going to work out, how they're going to affect their parental responsibility if it's equally shared. Prescriptive orders will set out, particularly what people have to do. That can be a godsend for people who would otherwise find that the abuse continues through 57 emails a day about whatever decision is about to come up. So in this situation, the key is to take clear instructions from your client about what the difficulties are or are likely to be, and to consider which way is likely to minimise those difficulties in the future. In terms of parenting arrangements generally, so this is living with and spending time with orders, I think it would be fair to say that a shared care arrangement is unlikely to be workable where there are serious allegations of abuse. You would more typically see that the children are going to be living with one party or the other. Either a court is going to be finding that there are risks and making arrangements for the children to live with the other party, or the court is going to find that there are no risks and they're likely to sheet home some blame to the party who is making the allegations, and decide in extreme cases that the children should live with the other party. So that's the party against whom the abuse allegations have been made. So more typically you're going to get a traditional type of arrangement where the children are living with one party and spending time or communicating with the other party. There certainly is a body of case law for orders where no arrangements are made for children to spend time or communicate with a party where there have been allegations of abuse, and that would be typically where the allegations of abuse have been made out, a risk has been established and the court has decided that it's unacceptable, and no orders whatsoever are going to be made about the children spending time or communicating with the party against whom the abuse is alleged. As I said, there is a body of case law. I wouldn't say that it's a common arrangement in courts. So parties who come to you seeking these kind of arrangements would need some advice about the likelihood of that happening, and the likelihood of it happening as a general rule would have to be considered to be low. The other type of orders that people would more typically get in these arrangements are orders for supervised time or for communication only, and perhaps for supervised communication, so the children don't have privacy for a phone call, for example, but it can be monitored by another adult, perhaps the other parent that they're living with. Those orders are more typically put in place where there are allegations of abuse, and certainly at an interim stage. If the allegations have not been made out to the satisfaction of the court at an interim stage, then more likely there's going to be orders for supervised time on the basis that that's managing the risk, and then the court will consider it on the final basis. Orders for supervised time and or communication on a final basis are unusual. It would depend on the type of supervision. Certainly the idea of a 12, 14-year-old child going along to a contact centre which they've been attending for the last 10 or 15 years and having supervised time at a contact centre is unusual, but there have been orders made along those lines. Long-term supervision orders are more typically made where there's a family member identified as appropriate for supervision, and those who tuned in to the webinar yesterday will have heard about the difficulties with finding an appropriate supervisor, but assuming that there is one that's agreed to be appropriate, that's more likely to be a long-term arrangement than a contact centre. But certainly the courts have and will make long-term orders for contact centres where there's nothing else indicated to be in the best interests of the children. Advising clients generally about parenting matters where there's allegations of abuse, there's a couple of things that you really need to obtain in your initial instructions. The first thing is whether or not there are current orders and when they were made. If the orders have been made recently, you really need to turn your mind to the likelihood of overturning or changing those arrangements. It's worthwhile asking whether they were made by consent or after a contested hearing. However, typically people who did consent to the orders and are soon or later asking about changing the orders will tell you that they were forced into making those orders. They were under immense amounts of pressure. They couldn't afford a lawyer. The independent children's lawyer told them that this was going to happen regardless. The judge told them that this was going to happen regardless, and that they were between a rock and a hard place and they had no option, they felt, but to consent. But regardless, it is worth finding out whether the orders are recorded to be by consent or after a contested hearing. If a contested hearing, how long was that hearing and how much evidence? Because from that you can glean how much evidence must have been produced at that hearing. The key question obviously is were the allegations exactly the same as the ones now being brought to your attention, or similar allegations ventilated in those previous proceedings? And I'm going to talk next about the way through the system depending on where your client's at, but that's going to be a key issue if you're talking about changing arrangements. The other thing to find out is whether there's current proceedings and the status of them. So are the interim orders already made? Is there a next court date, and is it near or far away? Has there been an ICL appointed? Has there been a family report prepared or pending? The context of these questions is to find out, what evidence has been put to the court for any interim orders, whether the court has already considered this recently, because if they have, a client doesn't have a great deal of standing to say, well, I'm making allegations of abuse and I'm now going to stop this time. If they've already had their day in court about that, either for previous orders or for recent interim orders, then it's going to be difficult to advise them to stop the time with an alleged abuser, for example. If the next court date is coming up soon, then clearly the answer is to wait until that court date and make your arguments then. Unfortunately, with the delays in the family law courts, at least in Brisbane, and I would assume in other registries as well, the difficulty is when the next court date is a long way away, what to do in the meantime, and we'll go through those procedures in a second. If there's an ICL appointed, it's worthwhile finding out what the attitude of the ICL is to the allegations, and if there's a family report prepared, have a look at that and see what it says about them. If the family report is pending, it may be a matter of waiting for that family report to be done, so you can have a look at it and see what the lay of the land is at that stage. So where there's no orders in place, and this could be either a recent separation where the parties just have not had a chance to put anything much in place at all, or a long-standing separation where the parties have been rocking along quite happily or unhappily, but regardless, without legal intervention, making their own parenting arrangements without any orders in place. Someone comes to you in this situation and says that there are serious allegations of abuse. What's the situation? They don't have a legal obligation to keep sending the children to the arrangements, however long-standing they've been or whatever they are. The paramount principle is obviously still the children's best interests, and the safety part of that is key. However, it's a difficult matter to advise clients in this situation because neither of their options is very good. Either they do send the children and they risk the abuse continuing, or they don't send the children and they risk the other party immediately applying for some sort of orders, and we'll come to that in the next section, some sort of orders for the children to start seeing them, and that the party who has stopped the visits is the one who tends to be on the back foot with explaining why they have done so. Oftentimes there's other procedures going on in the background, so there may be police or child safety investigations, and they're taking their own sweet time, but there's going to be no evidence available by the time the matter gets into the family law courts. So people are under a lot of pressure to make decisions about what to do with their children where they don't have any solid evidence, but the allegations have arisen, and they're under the threat of legal proceedings if they don't keep sending the children. Unfortunately, it's difficult advice to give to parties in this situation where they, as parents, have to make their own decisions about what to do in the best interests of their children and keeping their safety in mind. If there is some way of continuing visits, perhaps on a more limited or supervised way that they think will protect their children's safety, then that's something they should consider. If not, then unfortunately they have to make a hard decision about stopping the visits and taking the legal consequences. Either way, their first step should be to be directed into compulsory family dispute resolution, so a family relationship centre or similar for mediation, or if that's obviously not going to be suitable, they can get an exemption for that before going to court. People will often find it's easier to simply apply for FDR and get the certificate saying it's not appropriate once it's deemed that way by the FDR provider than to jump through the hoops of obtaining an exemption through the court, but they do have the options either way. If it's the party that's making the allegations, the best advice and best practice would be for them to immediately make an initiating application supported by an affidavit and a notice of risk in the family law courts, seeking whatever orders they think that they need for the best interests of the children. Obviously, in reality, that's difficult to do where parties don't have a lot of money to throw at private lawyers, and legal aid's not automatically available for parties in this situation, and certainly not at short notice. So ideally that would be the approach for parties looking to stop children attending visits where there are allegations made, but more typically they will be making the other party who has had the visit stopped will be the ones making the initiating application, and the parties having stopped the visits will be putting in a response. I don't believe there's a lot of difference between the party making the initiating application and the party making the response in terms of tactics of the matter. They both put in the same information to the court. Certainly there is an obligation on the parties stopping the visits to do something about it, but if they've at least attempted FDR, made a legal aid application, attempted some sort of mediation, they can often explain any delay in starting an initiating application that way. The matter will then go to a first court date, and parties should be prepared for interim orders to be made on that date. It's a mistake to advise clients who are blindsided perhaps by being served with an application to simply go along and get an adjournment on the first occasion. Most judges will be fairly reluctant to give that, in my experience, where there's either been a recent separation or a long-standing one and there's been arrangements in place. Either way, judges are reluctant to send parties in that situation away with no orders as to what's to happen with the children. It would be a rare case where allegations are very serious and the evidence gathering about those allegations, so police and child safety, is far enough advanced that you can convince the court of that no interim orders are going to be made and the court's going to wait and see and allow evidence to come in at a later date. Typically, judges will want to be doing something with parenting arrangements at that first court date. So be sure that your clients are prepared for that, or if you're appearing for them, that you're prepared for it. I'm not going to go into the court process to final orders at length. If there's more information required on that, just send me a question at the end and I can certainly elucidate that. But in terms of the time we have today, I'm not going to go right through those details. Just to highlight, obviously there is a court process to final orders. In Brisbane at least it's 12 to 18 months if it's going to a final hearing before a judge, and parties can only otherwise finalise it earlier by consent. Where there are orders in place, people do have a legal obligation, so they must comply with the orders or have a reasonable excuse about doing so. Again, children's best interests are paramount and the safety is key. So you're giving the clients the same hard advice that we talked about earlier about how they make a decision about whether the children continue to go on visits where there's allegations of abuse. Same situation in relation to compulsory FDR or obtaining an exemption. And then there's two options as to where matters can go after that. Typically, the person making a contravention application would be the person whose visits have been stopped. So they'd be making a contravention application with an application form, a contravention application form, and a supporting affidavit, which should state the outcome that they're seeking. So, for example, make up time and a revival of the current court orders and whatever else they're seeking. Someone responding to a contravention application need not file any documents but must attend at court. However, it can be useful in assisting clients to prepare for these hearings to assist them with an affidavit simply to ensure that all of their evidence is definitely before the court. Otherwise, that client is under a lot of pressure in the witness box and or on their feet in explaining the situation to a judge, and that can be difficult for parties to do. So it is often useful to assist them with an affidavit that they use in later proceedings. They don't have to file it at the outset. They can hold it until they need it, but to set down their instructions as to what's happened at that point so that they have that prepared and ready to go. It'll assist them, it'll assist the court, and it probably will lead to a better outcome overall. In Queensland, at least, the procedure for contravention applications is that they go before a registrar at first instance who provides a triaging type operation for those matters, identifies that the forms have been correctly completed and there is actually a contravention of orders alleged. The registrars can't dismiss those contravention applications, but they certainly can encourage parties to withdraw them if they don't make out a contravention. They can send the parties, if the parties consent, they can send them back to FDR if they think that that's worthwhile. They can make consent orders to settle the matter at that stage. They can't decide any contested issues. If the matter is ready then for a decision before a judge, it will then be sent to a judge for a hearing. The other option where there are orders in place and allegations have arisen, children have stopped going on visits, the other option is an application to vary the orders. So typically this would be made by the party making the allegations who wants to change orders for the children to see the other party to either supervised or no time. But sometimes the application will be made by the person against whom the allegations have been made, and that party will be seeking orders from the court perhaps to change where the children live. They'll be making an argument to say that the other parent's no longer suitable because they won't act in the children's interest by sending them on the visits, or for asking for some other sort of parenting arrangement. So one party will apply with an initiating application, a notice of risk and an affidavit, and the other party responds with a response, a notice of risk and an affidavit. goes through the court process for interim orders if they're sought, which they almost certainly would be in this situation, and for final orders made by consent or a judge. Same process there, and the same advice to clients that at the interim stage, the first day in court, they should be ready for orders to be made at that point. It would be unusual for matters to be adjourned off with no orders at that stage. Where there are pending proceedings on foot, it's much the same situation, but there's a few variations. Again, parties are required to comply with orders unless there's a reasonable excuse, act in the best interests of children, and make those hard decisions about whether or not to send children and under what arrangements. If there's an independent children's lawyer appointed, they should be alerted to the issues, and you should seek to find out whether the ICL has a view about the children attending visits or not. Typically the ICL won't be able to say at that stage because almost certainly there won't be sufficient evidence either way, but certainly make sure that the ICL is advised. Also advise the other party obviously of what the situation is. So if you're advising the client who's making the allegations and you'd be saying, well, if we're only offering supervised time or no time or for whatever reason, if you're acting for the other party, you'd be seeking that the arrangements continue, or perhaps erring on the side of caution, offering some supervised arrangement as an interim measure until a matter can be resolved. There's two options then, depending on whether the next court date is distant or coming up soon. If it's coming up soon, then all you need to do is file an amended affidavit and perhaps an amended application or response, if that's required, for the next court date to consider. If the next court date is months and months away, you can try filing the application in a case and hope that you get an earlier interim hearing date. It won't always happen. It will depend on the court calendar, and in Brisbane at least it's quite difficult to get those earlier dates, but that's your only option. Either way, the matter is going to be dealt with at the next court date, and the court process is going to rock along to final orders made either by consent or by a judge. Probably the key to this whole process is to obtaining the quality of the evidence that's going to go before the court. Clients filing affidavits in these matters need to have very relevant and specific information contained in those affidavits. So it will not be sufficient for clients simply to say there's been abuse going on for years, or the respondent has always treated the children badly. The clients really need to be assisted to go through and sit down and work out a very detailed timeline as best they can. It's fine to say on or about 2 years ago or at around Christmas 2014, but to be as specific as they can about what their allegations are. It's also important that the allegations are relevant to the questions at hand. So where we talked about the domestic violence matter, about not muddying the waters between domestic violence and parenting arrangements for the purpose of those protection orders, the same thing goes for family law courts matters. Domestic violence is a relevant matter to be considered by family law courts in parenting matters, but where there's abuse allegations, it's very important to separate out the two and make it clear that they're not being confused or conflated in any way. Simply because, rightly or wrongly, a lot of judges will have different views about the weight to be given to children merely being exposed to domestic violence and other forms of direct abuse alleged. So be very clear in separating those out and very, very specific in terms of the type of allegations made, when they were made, and to whom. The other key in drafting clients' affidavits, checking them or assisting them to write them themselves, is to, as far as possible, ensure that they do not conflict with statements given in other fora. So if parties have provided a police statement, if they have provided something to child safety, if they had done a previous protection order and they're now in family law courts, if possible, best practice would be to obtain those statements and be very, very sure that the client is not making inconsistent statements, or even just omitting things from one statement to the other. If that has already happened in things that have previously been provided, then you have the opportunity to explain and correct that in the client's affidavit. That would be useful to do. Otherwise, just ensure that the affidavit is comprehensive and covers the ground. In terms of obtaining affidavits from others, the family law courts hate cheerleaders' affidavits, so obtaining affidavits from other people who are simply saying, yes, we've noticed that the children are not doing so well, also are not going to be helpful to the court. Affidavits from others, other than experts, which I'll talk about in a second, but affidavits from others can be required where the allegations have been specifically made to other parties, so where children have gone to a grandparent or a neighbour or an auntie and made specific disclosures, then obviously those people should file an affidavit. But if the evidence in an affidavit is simply supporting what the client themselves are saying in their affidavit supporting their application or response, then those affidavits are useless to the court and are not required. So I would avoid those or steer clients away from them. Where disclosures have been made to, say, a school counsellor or others, then it's necessary to obtain a report from that party, annex it to an affidavit with a CV of the party, and if there are already reports in the court and you're attempting to obtain other single expert evidence, follow the rules in relation to that. Probably in most cases you're not going to have any of that. You're going to be working from scratch trying to put the evidence together or assist the client to do that. And your key measure in doing that is going to be to obtain subpoenas. So schools, hospitals, police, child safety, wherever your client instructs you, there will be information held in relation to the allegations. And I've set out as a little handy re-reckoner the typical kind of wording for a subpoena in that situation. Once the subpoena material is in, it's going to be important if you're acting for a client or assisting a client who's acting for themselves to have a fine-tooth comb through that subpoena material and see what it actually supports. So clients will often have a view of what they think child safety or police records will say, and this might be based on something that a staff member at one of those places has said to them, which tends to suggest that they believe the client or that they believe the children or whatever else it might be, but that may not be borne out in the official records. So it's important to do some reality testing at that stage once that evidence is in, and to assist the client to understand the amount of weight that's going to be provided to that evidence by the court, which is substantial, and to consider what the client's next options are after that.
Sorry, Steph, there was a question about...
There's a question come through. James is just going to assist me. The question is, how do you separate the family violence allegations and best interests of the child in an affidavit? It's not necessary to separate out those two things because family violence allegations do go to the question of what's in the best interests of the child. The point I was making in terms of separating out the two different types of instructions was allegations relating specifically to domestic violence against the adult, the parent, and saying, well, the child has been exposed to this, and other allegations relating to other forms of abuse specifically against a child. It often happens that these things get conflated all into the one. So you'll get very general statements saying the father has abused the children and me for years, and then perhaps going into a lot of allegations about the abuse of the adult. That is a relevant consideration. Family violence is certainly a relevant consideration. However, rightly or wrongly, not all judges will give as much weight to that as a form of child abuse as to direct allegations of abuse against a child. So if you were drafting an affidavit in this situation, I would tend to be focusing as much as possible on direct allegations against children where there are such allegations. It's not to say that the family violence is not relevant. Certainly it is. It should be given equal weight, but in my experience it isn't always, and it's a mistake to write an affidavit full of allegations of the domestic violence from one adult to the other, respondent to applicant in parenting matters, say, and to not give equal time in the affidavit or really more time and detail to the instructions that you're able to get about allegations about abuse directly towards the children. If there is no allegation of abuse directly towards the children, then be very, very specific in the affidavit about the children's exposure to the domestic violence. So be very clear as to where the children were when the domestic violence happened, what they saw, what they heard, what they said afterwards, what effect it had on them, what their teachers said happened to them afterwards. Anything like that that you can draw into evidence is going to assist the court where the allegation is purely that the children have been exposed to family violence. Be very focused on the children. Focusing merely on the adults is not likely to play out well with most family law courts judges who are looking specifically for best interests of the children and who do say to parties, it's not about you, I'm interested in the children. So just be very careful in how you draft things in that regard. I hope that's of assistance. If it would assist, I do have some precedent affidavits that assist in specifying that out a little bit more, so I can certainly look at adding that to some materials to send out. And that brings us to any other questions that might have come through. So I've only got 5 minutes, but as I said, if there's a question that simply suggests that we need some more material, I'm happy to send it out after the presentation. I'm going quiet because James is just clicking through looking for any other questions.
Unmute Lisa, who's had her hand up.
Lisa Stewart has had her hand up. Hi, Lisa.
Hey, Steph.
Yes, we can hear you.
No, the little hand just keeps going up and down randomly.
Oh, the little hand just keeps going up and down randomly.
Yes, it just went up again.
Nice to speak to you anyway.
Some precedent affidavits would be good.
Precedent affidavits? No problem. I'll add that to the material.
See, it just went up again.
Okay. Thanks anyway. Anything else?
So just a reminder,
yes, there's been a few requests for some additional materials which I can certainly arrange to send out. It won't come out with the PowerPoint because I haven't come prepared to James's office with those on a stick, but I will make sure I get them through shortly. Further question has come in about the affidavit precedents and case law, which I can certainly send through. Top 5 risk factors, which we talked about yesterday, and CPD points.
So that's really a matter for self-assessment under the Queensland Law Society rules or the rules of the relevant professional association in each state or territory.
Anything else? Well, thank you very much, everyone. I certainly will send through the additional materials, and if you have any other questions, you're very welcome to contact me and I'll assist as far as I can. Can I wind up anything?
Guys, it's James here. Just quickly on your behalf, I'd like to thank Steph for a very detailed and thoughtful presentation that really works well with the presentation we had yesterday around allegations of abuse and how we can respond to them. We'll send around some materials, the PowerPoint probably later today, and some other materials in the next few days. Thank you all for participating. Thanks especially to Steph, and we'll speak to you soon.